Welcome to Civil Procedure, Subject Matter, Jurisdiction, Video 3. In this video, we are going to continue our discussion of diversity jurisdiction, and the case that we are going to use to apply what we're learning in this video is the Hertz Corporation v. Friend case. Hertz Corporation v. Friend. In diversity jurisdiction, the federal court can only exercise subject matter jurisdiction over the lawsuit if the plaintiffs and the defendants are citizens of different states. We must have complete diversity. For individuals, that citizenship is determined by domicile. We learned that in the Moss v. Perry case. For corporations, Congress provided a special rule in 28 U.S.C. 1332 C1, where citizenship is determined by 1, the state that the corporation is incorporated in, and 2, the state where the corporation conducts its principal business. So before a federal court can exercise jurisdiction, it must answer this gateway question: where is the corporation a citizen? Today's case is Hertz Corporation v. Friend, 559 U.S. 77. It is a 2010 case. So in terms of our rule of law, it's relatively recent. Our focus again is on diversity jurisdiction for corporate citizenship. Let's turn our attention to the rule of law. The rule of law that governs corporate citizenship is 28 U.S.C. 1332 C1. And it states, a corporation shall be deemed to be a citizen of every state and foreign state by which it has been incorporated, and of the state or foreign state where it has its principal place of business. Sounds pretty straightforward. It is not. What we seek to resolve is not the every state and foreign state by which it has been incorporated. What we seek to resolve is, what is the state or foreign state where it has its principal place of business? What exactly does that mean? Continuing with Hertz v. Corporation, here's a brief procedural history. In 2007, Ms. Friend and Nihu, both California citizens, sue Hertz. They sue Hertz in California court. The nature of the claim is a wage and hour suit. The plaintiffs were alleging that Hertz violated some labor laws, okay? They sued in state court, great. They were seeking damages and relief on behalf of a class of California citizens that were similarly situated. Hertz comes in and files a notice to remove. A notice to remove. Mind you, I did not say a petition to remove or a motion to remove, because that's not how removal works. Removal goes one way. It goes from state court, removed to federal court. It does not go vice versa. You don't remove from federal court to state court, okay? Removal works one way: from state court to federal court. And the logistics are this: if you are a defendant and if you believe that it is to your strategic advantage to have your case heard in a federal tribunal, well, you have to make sure that the case could have been filed in the federal tribunal initially. Hertz argues that this case is based in diversity. Because it is based in diversity, it could have been filed in the federal court. So Hertz files its notice to remove to federal court, and it is now removed. Okay. Plaintiffs challenge the removal. If you're going to challenge the removal, you don't challenge the removal in state court. The removal challenge happens in federal court. And so the plaintiffs challenged the removal to federal court. The plaintiffs argued that Hertz is a California citizen. And because Hertz is a California citizen, and because the plaintiffs are domiciles of California, then diversity is defeated. What was the evidence? What was the evidence? What was the evidence submitted by Hertz? Hertz said, look, our employee relations manager has sent in a declaration. And in that declaration, it declares that Hertz has facilities in 44 states. It declares that California has a significant share of the operations, but it further states that the corporate leadership and its headquarters is not in California. The corporate leadership and its headquarters is not in California. So Hertz was arguing diversity, right? Hertz is saying our incorporation is not in California. Our principal place of business is not in California. So we are a citizen of a state other than California. The plaintiffs are domiciled in California. Therefore, diversity. Therefore, we stay in federal court. Yay. Not yet. Not yet. Very, very interesting turn of events. The district court, who is hearing this challenge to the removal, agrees with Hertz. Agrees. Absolutely. We acknowledge that your incorporation is a state other than California. We also acknowledge that you believe that your principal place of business is somewhere other than California. However, based upon your declaration, Hertz, you have an awful lot of business activity taking place in the state of California. You have a pretty significant share of revenue out of California. You have a regional office in California. You have lots of business happening in California. So while we've heard your argument, we use the evidence that you have submitted to find that you are a citizen of California. Oh, no. Oh, no. Hertz's evidence was persuasive enough for the trial court to believe But the trial court, this is the federal trial court, took that evidence and used it to establish that the principal place of business for Hertz was, in fact, California. Well, of course, Hertz appeals, goes up to the Ninth Circuit. The Ninth Circuit applies the business activities test. The Ninth Circuit applies the business activities test. What is the business activities test? Well, the business activities test is how much volume and how much business are you doing in any particular state. If you are doing a lot of business, if you have heavy volume in any one particular state over other states, then you will be deemed to have your principal place of business in the state where you have the greatest volume of business activity. So what happens? So the Ninth Circuit is affirming what the lower court said, which was because of the volume of business that you have in California, California is your principal place of business. What does that mean? That means that the federal court is going to remand the case back to state court. Hertz is saying, no, 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 no. We don't want to be in state court in California, right? We just don't want to be there. Now, there's lots of reasons, and we don't need to go into the speculation of why Hertz may have preferred federal court over state court, but some low-hanging fruit is you have potentially a class of California domiciliaries suing you in California state court. Hmm. Hmm. The courts are extremely objective, right? That's not an issue. That's not a problem. But if I am the attorney representing Hertz, understanding that ABA model rules are requiring me to be tactical in my strategy, meaning forum selection needs to be given some consideration. Giving those facts, I might think that I can find a more objective tribunal in the federal court. Maybe. Yeah. Okay. With all of that being said, Hertz appeals. Hertz files a writ of certiorari to the Supreme Court, and the Supreme Court states that one of the reasons it granted certiorari was because there was a split in the circuits as to what the definition of principal place of business was. As you see in the Ninth Circuit, principal place of business was decided by a business activity test that looked at the volume of business that was done. Right? So one circuit's doing one thing, another circuit's doing something else, and maybe another circuit is doing something else completely different when it comes to adjudicating the principal place of business of a corporation. One of the reasons we have a federal court system is to try to bring in line, make consistent adjudications that involve matters that may apply nationally, right? And so the Supreme Court is the perfect forum to get some simplicity and some consistency about how the term principal place of business is going to be defined when it comes to diversity, jurisdiction, citizenship of corporations. That was a really pretty exciting procedural history. With that being said, let's go ahead and take a look at the issue. Again, 3-point issue statement. What rule of law is going to govern 28 USC 1332 C1? What is the actual legal question that is being asked? What is the legal question that is being asked? Here it is. Is a corporation's principal place of business determined by the state with the largest share of its business operations? That's the business activities test that was applied by the Ninth Circuit. Or is it determined by the single place where the corporation's high-level officers actually direct, control, and coordinate the corporation's activities? Where is it? Where is it? Well, Hertz is going to answer where it is. Let's look at the parties. We have Melinda Friend and Jean Nui, California citizens, California domiciles. We have the defendant, Hertz Corporation, incorporated in Delaware, right, with a corporate headquarters in New Jersey. Its core executive and administrative functions are directed from New Jersey. Now, there's some additional administrative operations in Oklahoma City, but the core executive functions are out of New Jersey. Yes, Hertz conducts business at the time, 2010, in 44 states across the United States. Yes, the California footprint for Hertz was pretty large, right? 273 rental locations in California, but that's only 17% nationally. 2,300 full-time employees in California. That's a good number of full-time employees, but relatively speaking, nationally, that's only 20%. $811 million of revenue comes out of California. Right? That's not something to sneeze at. $811 million. But the total revenue nationally for Hertz is $4.37 billion. So the 811 millions, roughly 19%. Okay. And then 3.8 million of 21 million annual transactions come out of California. That's roughly 18%. Now, if we look at the 44 states that Hertz is conducting business, California by far is going to be the largest market. California by far is going to be the largest market. And the second largest, I don't even remember what the state was, but it wasn't even close. Yeah. So if the federal courts in the Ninth Circuit are defining principal place of business as the state where the lion's share of business activities are taking place, well, it makes complete sense that the federal district court, that's the trial court, and the federal appellate court, that's the Ninth Circuit, found that California was the principal place of business for Hertz because the plaintiffs were citizens of California. There's no diversity. Makes absolute sense. Absolute sense, right? Okay, let's continue on. Let's look at the fact element map, right? You know how I like to show you the element, right? You know that I like to show you the fact how we connect those two things together to come up with an outcome, and then look at how that outcome can be used in our analysis. So let's look at the first fact. In our chart, and I've got the columns a little different than normal, but the fact column is going to be the one in the middle, right? The fact column is going to be the one in the middle. If I am looking at this chart, the first fact that I see is going to be the fact that Hertz is incorporated in Delaware. Well, where does that fact go? It's going to go with my state of incorporation. Remember, 28 USC 1332 C1. What's the very first paradigm? State of incorporation. Okay. Where is Delaware incorporated? I mean, where's Delaware? Where's Hertz incorporated in Delaware? What is the outcome when I put the fact that Hertz is incorporated in Delaware and I wed that to the element of state of incorporation? The outcome of that is Hertz is a Delaware citizen. So how can I use that in my analysis? It's very straightforward. Hertz is a Delaware citizen. Done, right? Okay. Well, let's look at the principal place of business. Let's go back to the jurisdictional fact. Let's go back to the jurisdictional fact. Hello?
Hello, this is PennyMac Loan Services contacting you regarding essential information concerning your home loan. Stay up to date on the status of your loan.
The corporate headquarters, according to Hertz, is in New Jersey. Hertz said that their headquarters was in New Jersey because the leadership was in New Jersey. The direction for the company came from New Jersey. All of the hard decisions about the soul, the essence, the spirit of Hertz comes out of New Jersey. Okay, what do I do with that fact? Where is it going to go? Is it going to go with the state of incorporation? No. Where is it going to go? Well, it's got to go under principal place of business. Okay. When I wed those facts with the element of the principal place of business, what am I getting? Well, I'm getting that the leadership, the direction, it's really coming out of New Jersey. Got it? All right. Fantastic. Let's go further down on the chart. Let's go here. Where is the leadership and control? Where does that lie in Hertz? According to Hertz, that's in New Jersey. Oh, okay. Okay. Where does Hertz operate business? Hertz operates business in 44 states. Okay. All right. Once we look at the fact element chart, we look at the wedded outcome and we analyze that outcome, we get the holding. In Hertz v. Friend, the Supreme Court held that for purposes of diversity jurisdiction under 28 USC 1332 C1, a corporation's principal place of business refers to the, pay attention to this next word, refers to the single place where its high level officers direct, control, and coordinate the corporation's activities. activities. Here it is again, 1332C1. A corporation's principal place of business refers to the single place where its high-level officers direct, control, and coordinate the corporation's activities. A location that is sometimes referred to as the nerve center. What are we talking about? We're talking about diversity jurisdiction. Okay, so now we're using the term nerve center. The nerve center will ordinarily be the corporation's actual headquarters, provided that the headquarters is the true center of direction, control, and coordination. Direction, control, and coordination. The Supreme Court rejected the Ninth Circuit's business activities test, which would have located the principal place of business for Hertz in California. Applying the standard of high-level officers direct, control, and coordinate the corporation's activities, applying that standard, the United States Supreme Court concluded that Hertz's principal place of business was in fact New Jersey, not California, despite conducting a significant portion of its business in California. Accordingly, Hertz was a citizen of Delaware, that's its state of incorporation, and Hertz was a citizen of New Jersey, which is where its nerve center is located. And for those reasons, complete diversity with California domiciliaries existed. As such, what happens? As such, the case gets to remain in federal court. Yeah? Let's look at the rule. The anchor rule. Principal place of business for diversity, subject matter, jurisdiction matters refers to the place where a corporation's high-level officers direct, control, and coordinate the corporation's activities. That pause was intentional. Just wanted to let it sink in. Here's some sub-rules. We've talked about this a little bit already, right? Anchor rule versus sub-rule, one versus the other. Why do I need an anchor rule? What's my sub-rule? The anchor rule is the rule that you write when you're writing your rule statement. The anchor rule, that's the anchor. That's the anchor. That's the foundational pillar. That's the rule of law, right? When do you add sub-rules? You add sub-rules if they are needed to address the specific call of that question. If they are not needed to address the specific call of that question, then you don't discuss them, right? So this is just some of the sub-rules that we get out of Hertz, and I gave you the Penn site if you actually want to go and pull the original opinion so that you could read this for yourself. But I transferred these into a table, so it's just a little bit easier to track. Again, this has been posted in your Canvas. I know that these words are tiny. You might not be able to read them as we go through the video, but because it's been posted in Canvas for you, you at your leisure can go in and blow this up, or you can go in and you can print it, or you can even go in and change the color of it, make it bold, whatever it is you need. if this is helpful for you, but we're just going to take a couple. Let's look at the first sub-rule. This is the singular place requirement. Here's the quote that comes from Hertz. The word, quote unquote, place is in the singular, not the plural. The word principal requires us to pick out a main, prominent, or leading place. The statute uses the word place to establish that there is a singular place where there is a principal place of business, right? There's a single state for incorporation. There is a single state for principal place of business. This singularity is important because it avoids confusion and prevents corporations from being treated as citizens in multiple states. Got it? Let's look at this not the biggest footprint sub-rule. Here's the quote. By contrast, the application of a more general business activities test has led some courts, as in the present case, to look at the state itself, measuring the total amount of business activities that the corporation conducts there. This approach invites greater litigation and can lead to strange results. That's why we don't look at the business activities test. Got it? Yeah? All right. There's some of your sub-rules. Let's keep moving through, and let's see where we are. We began our journey with diversity jurisdiction as a subject matter for federal courts with Strawbridge v. Curtis. That's where we began. In Strawbridge v. Curtis, we get the rule for complete diversity. We learned in Moss v. Perry that for natural persons, citizenship is based upon the domicile. That is the physical presence and the intent to remain indefinitely. And now in Hertz, the Supreme Court settles the corporate side of the equation. A corporation is a citizen of the state. Hello? Hello?
Hey, how you doing? This is Miss Washington?
Yes.
Yes, ma'am. Brad gave me your number about some air conditioning work. You said they have a problem at one of your houses or something?
Okay. I've got somebody coming out today.
Okay.
Okay. All right. Thank you.
Yes, ma'am.
Okay. Bye-bye. And now in Hertz, the court settles the corporate side of the equation for corporations. A corporation is a citizen of the state where the corporation is incorporated, and it is a citizen of the state where the corporation has its principal place of business, and that is defined as the place where the high-level officers direct, control, and coordinate the company. This closes the loop. Citizenship for individuals is based upon the domicile. Citizenship for corporations is based upon the state of incorporation and the state where their high-level executives direct, control, and coordinate the company. So when you analyze a diversity problem going forward, you now know how to complete the framework. You have to identify the citizenship of the individual if that's the call of the question, and you do that with the domicile test. Or you have to identify the citizenship of the corporation if that's the call of the question, and you do that by identifying where the corporation is incorporated and where the corporation has its high level officers direct, control, and coordinate the company. We've confirmed that complete diversity is what is required, and we've addressed the amount in controversy. We did that under Moss v. Perry as well, where the amount in controversy that is pled by the plaintiff will be presumed to be pled in good faith in the absence of evidence otherwise. Subject matter, jurisdiction, wrapped up with a big, pretty bow. That is the doctrinal package for diversity jurisdiction. And with Hertz, we're ready to pivot from who the parties are and how we determine the citizenship of the parties so that we can determine whether or not the diversity is complete, and turn to federal question jurisdiction under 1331. Ah, there we go. We're done. Where we've been, you see it. Where we're going, 1331. What's the roadmap for our journey through federal question? We're going to start with Osborne, which was not initially assigned. We're going to start with the Osborne case. We're going to move to the Motley case, and then we're going to move to the Minton case. I hope this video helped. I look forward to interacting with you on the next video when we start the subject matter jurisdiction series that's focused on federal question. Thank you.